Hello, everybody. Welcome to our weekly series of webinars. Hope everybody is staying safe and well. Prayers to those who aren't. Looks like we are having some outbreaks. I know the local high school here is closed down, hopefully temporarily. So please continue to practice super hygiene. We want all of you guys to stay healthy and well. I'm John Miller, founding attorney with Rock Solid Law. Began my independent practice in 1991 after starting my practice in 1984. That's amazing to say that. It sounds like a long, long time ago, doesn't it? So this morning, I've got what I think are some interesting materials for you. Basically, this is that time every 4 years when everybody tries to get out their crystal ball and figure out what if this happens, what if that happens, and what effect, particularly in my field, will that have on our estate planning future. So let's dive right in. First, Rock Solid Law is your no judgment zone. So I like to tell a little story on myself. After my wife and I had our daughter, I got all of our affairs in order. So the cobbler's children actually did have shoes for a period of time. Did our estate plan and all the documents for my wife and me. And then lo and behold, some years later, along came our little son. Well, even though my wife had reminded me to please update our plan, you know how it goes, the story about the cobbler whose children's never had shoes. I've always prioritized our work last. So it took 2 years before I updated our plan. I'm proud that I did get it updated, but I always tell folks that for the first 2 years of my son's life, the carrier of the family name, the fruit of my loins, the scion of my family tree, in our estate planning, he was known as, quote, all afterborn children, end quote. Finally, little Ian did get mentioned and has been a named part of our plan for a long, long time. Of course, he would have been fine had we gone during that window, and thank goodness we didn't. So we've gotten to know him. And now a first grader practicing spelling words this morning for school. So the point of me telling you that is that a lot of people put off estate planning, deprioritize their own plan. And so I never give anybody a hard time for having done that. And let's, excuse me, it's never happened before. As I told you, I'm an older dad. I had my kids late. Don't get me wrong. I intend for the last third of my life to be amazing. But what I really care about is leaving my kiddos better off than I had it growing up. I had it great. But we were solidly middle class. And I would like to give my kids a little more of a boost into the future. I have found in my 6 years of practice now that everybody cares about something. It's not our job to figure out what you care about, but it's our job to make whatever you care about a reality. And it's our job to continue in an ongoing manner to make it better and better if there are changes that occur. So thank you so much for spending a little time with me this morning. We do these weekly. Hopefully we'll get back to live ones at some point in the not too distant future. We have been experimenting with different times a day. We're back at this hour today. So listen, there is a chat bar right in here. There's also, I believe, a question spot, question and answer. I will check both of those before we sign off. So there's no bad questions except an unanswered question. If it's a general question in regard to the subject matter, I will take it right here during the Zoominar. If it's very fact specific, I'd be glad to answer it sort of offline without the rest of the group being part of what we're talking about. So what are we going to talk about today? Well, I'm going to tell you what we're not going to talk about today. We're not going to talk about politics, even though our subject is, what if this happens? What if that happens? What might be the result for estate planning? We're not going to get into a political discussion. I believe we're under 20 days to the election now, and a lot of people have already voted. We're also not going to talk about a bunch of acronyms for estate planning devices. I think a lot of lawyers like to throw out all the terms they know for all the fancy trusts that are available to you. And I'll be glad to talk about those one-on-one anytime anybody wants and discuss how they could affect your life. But I think lawyers just do that to make themselves feel better. I have one law school friend who's now practicing in England, and he says lawyers like to sprinkle Latin about like so much salt and pepper just to flavor our conversation. Sometimes I think it's to just make ourselves feel better. So for those of you that do work with us, thank you. For those that don't yet, our focus is on your values, what you care about in the planning. And it's so important to realize that getting your plan done is amazing and awesome and makes you better than about 85 to 95% of fellow Americans who either don't have a plan at all or have an outdated one. But just like driving a new car off the lot, it's important to see the mechanic occasionally to keep it running well. It is important to tune up your plan. So one of the things we think about quadra-annually, every 4 years, is what if such and such happens? What if such and such happens as a result of this election? And what are some plausible results of that? So there are actually 3 possibilities of what could occur in the election, right? I guess there are more, but basic 3 possibilities. 1, we end up with a divided government like we have now, where one of the houses in Congress belongs to one party, one has a majority of the other party, and the executive is one or the other. The overall prediction, and I've gone out, of course, and done some research in preparation for this, is that there's likely going to be gridlock, and you can anticipate more of what we have now, with some caveats, which we'll touch a little later in the next half hour. The second possibility would be a unified Republican government, which would mean they hold on to the White House and flip the House of Representatives to Republican. Broad brush, we would believe that we would either maintain the current tax rates or lower tax rates further, as we saw in 2017. Obviously, in all this discussion, a wild card is what's going to happen with COVID in the future. None of us know that. So again, please don't take what I'm saying this morning as legal advice. We would want to look at your specific facts to make any proposals for future determinations. And there are wild card factors right now. So I'll discuss a little more of that later. Then the third option, of course, would be a unified Democratic government, which would mean that the Democrats take the White House, the executive, and also the Senate. In that instance, we anticipate higher taxes, income taxes, and increase for corporations and higher income people. And we would anticipate taxes being increased beyond income taxes as well. We would anticipate a rollback of the current administration's lifetime gift and estate tax exemptions, and potentially eliminating the step up in basis on inherited assets. So 4 years ago, right, most prognosticators guessed correctly that President Trump was going to reduce the corporate tax rate. That happened. But doubling the estate and gift tax exemption to more than 23 million for a couple from an already generous 11 million was a bit of a surprise to most. I'm saying this because there are always post-election surprises that people don't anticipate. Also, the elimination of deductions for state and local taxes was a surprise, and that disproportionately hit the Northeast and states like California that have high tax rates. We Floridians benefited disproportionately, I would say, from that, but we like that, right? So all of this is saying, as 4 years ago, Who knows what's going to happen? What we do know, the current federal estate and gift tax exemptions, which is the amount individuals can transfer free of estate and gift tax over the course of his or her lifetime or death, are at 11.58 per person, which is 23.16 million per married couple. That means that often we do not need to take that estate tax into consideration in planning most middle income people. These exemptions are the highest they've been since estate tax was implemented in 1916, so the highest for over 100 years. The transfers during lifetime or at death in excess of the above exemption amounts are currently taxed at a rate of 40%. And we also know that a change to the exemption amounts enacted by a new president in Congress could be effective, listen up, as soon as January 1, 2021, if Congress passes legislation that has a retroactive effect, and they can do it. Most tax commentators believe that the current exemption amounts are the best we're ever going to see. So, there's no planning that can be done in anticipation of the possible elimination of the step-up in basis, or there's not a strategy I'm aware of. I would love to hear that if somebody knows it. I see there are a few professionals that have joined us this morning. There are ways to take advantage of the current estate and gift tax exemptions before the changes are made. So to be absolutely certain, those changes to your plan would need to be made by December 31st, because a new legislature, even though they don't come in until late January, could pass a bill with retroactive effect. First and foremost, we want to plan to achieve goals other than just estate tax elimination. Why? Because then even if the new Congress, the new president, if there is one, don't change the laws, you've accomplished other goals. So, for instance, gifting assets to an irrevocable trust can provide great planning to minimize liability exposure. Liability exposure is something we always want to consider when we're doing a plan for a family. Some other strategies to consider. One, accelerating income into this year and deferring expenses and losses. At least one participant on this call will be glad to hear me say you will want to see your CPA about that in your particular fact situation. Two, you can make gifts to the irrevocable trust. Gifting assets outright or in trust now, while the exemption levels are still at their historic high, essentially allows taxpayers to lock in the current high exemption rates. Three, due to the anti-clawback regulations issued by the IRS in 2019, you may make taxable gifts and use the increased exemption now. Such gifts will not later be subject to tax even if the increased exemption expires. Okay, so making those gifts now will not be clawed back or forward into the future for tax purposes. For those who have the resources to make such lifetime gifts, it might be prudent to do so now in order to use some or all of the increased exemption while it's still available. Again, that likely means by the end of 2020, if there is retroactive legislation passed. 4, you could sell assets in exchange for a promissory note, a note which could be forgiven later. This would be transferring assets to people in your inner sphere, let's say. 5, life insurance, including private placement, to provide tax-free accumulation may be a good play now. 6, taking advantage of the high estate tax exemption and valuation discount around closely held businesses could allow business owners to pass more of their wealth to heirs free of tax, generational tax planning. It could also help settle some business issues now, not later when the owners die. What am I on, 7? The CARES Act in March responded to the extraordinary pressures of the COVID-19 pandemic. For 2020 only, the limit on income tax deductions for charitable contributions is increased from 60% to 100% of adjusted gross income for outright cash gifts to public charities. So for people who are interested in making a large cash gift to a charity and getting a big income tax deduction, they should talk to their tax advisor about making that gift this year. That means 2020 would be better for the charity chosen, and for the individual who can claim the tax deduction. Finally, the simplest proactive action to avoid that gain might be to make gifts now to long-term trusts. The gain would still be taxed eventually when the trustee sells an asset, but that time it can be controlled, and this is especially useful for assets that are not expected to be sold, or at least for a long time. Well done, team. I would like to let you know that every single person hung in there with me through that discussion. So glad you're here with me this morning. Okay, so I often like to play this game live. It's harder to do now, but I ask folks, what is your biggest expense? And people usually say, housing, my mortgage, my rent, or food. I thought that was a funny one. I got that one recently. Groceries are up there. But no, really, our biggest expense is taxes in this country. So if you have, for any of you that are on the call, who have qualified retirement plans, retirement investments, we're talking SEPs, IRAs, and other qualified retirement plans. We generally think of that as 100% ours, looking forward to our retirement. But remember, we put those funds in, it grows tax-free, but it's taxed when it comes out. It's taxed if it comes out to you, and it's taxed if it comes out to your heirs. So interestingly, the amount in qualified funds right now is roughly the equivalent of the national debt. And if you don't think there are folks in DC that are looking to that savings to help the federal government in the future, you're sadly mistaken. And in fact, the Secure Act, which was passed earlier this year, and remember, that was passed with a Republican-controlled Senate and signed by a Republican president, who most people thought would never sign such a law. That took away the stretch out on inherited IRA. Before, your heirs could take that money over their lifetime, their anticipated lifetime. Now they must take all that money within 10 years. And if you think about the common lifespan, most people inherit their parents' leftover bounty during the years when the heirs, the children, are in their greatest earning capacity. So the addition of having to take that income often pushes them into a higher income bracket. So with that in mind, I'd like to ask if it would be important for you to make your retirement income tax-free. There are ways of doing that, and that is a strategy which I think everybody who has children and is doing multi-generational planning should consider. As an example, did you know that you can get a tax deduction now, today, for a charitable gift that you don't make until after both you and your spouse pass away? That is an opportunity right now. If you wait until taxes go up, perhaps under a new administration, we like to say that any taxes you pay after that point in time are strictly voluntary. Why? We look at it as though there are two tax codes in America. One is for the informed and one is for the uninformed. And one of our jobs, like what we're doing today, is to inform you of what possible benefits may be available to you under the tax code as it currently exists and as it may exist next year. For those of you that have done nothing at all, your first problem has been that you haven't done anything to alleviate the cost, the publicity, and the time waste that is a probate action. We at Rock Solid Law consider ourselves an anti-probate device. We want to let the probate judges live quietly and not have to govern over your estate. We like to get you into the type of plan which will totally avoid the government through the courts after you're gone. And it tends to leave more of an opportunity to celebrate your life. It tends to mean your heirs don't fight as much at that time. So for those of you that have done something, as I indicated earlier in the program, people outgrow their plans all the time. It's not a car you drive off the lot and never have to change the oil, right? There are tune-ups that need to be done constantly to an estate plan. And I would suggest that these next 20 days, and certainly by the end of this year, would be a really good time to have a review done. We would love for you to consider working with Rock Solid Law. For those of you that don't know us, we consider our planning to be all about YOU, about you, about how you wish to be treated as you age, because estate planning is as much about you as it is about your heirs. We write the ultimate chapters to your heroic life story, so you'll be celebrated, not fought over after you're gone. It can be about your heirs, it can be about your legacy. Most of us, I find, care about something bigger than ourselves, and we want to help you put that into writing, taking into consideration that a change is likely to come. We want to make sure you only pay mandatory taxes, and that you do not also choose, maybe by inaction, to pay voluntary taxes. We're going to maximize your prosperity during your life and decide how you're going to share your life's abundance with those you treasure, all at the least expense possible. That's important, that we look at the ways in the big picture at the least expense for you and your heirs. Listen, estate tax, capital gains tax, and probate are all taxes that can be voluntary. We don't want to subject that to you. So, looks like I did pretty well. I'm right at the half-hour mark. Oh, I just see there's a question, and someone is telling me that the video stops briefly for a couple of seconds every 3 minutes. How annoying. One of the people online has said that's occurring to them. If that's happening to you, will you let me know also, because that could be a Zoom issue. I know that they've experienced unbelievable growth this year. I hope all of you bought a few shares. So we'll get that checked into. Thank you, sir. So I wanted to thank all of you for taking the time to be here this morning. I want to let you know this is a pretty exciting thing that's happened in the last 2 years of my practice, and I've been invited to be a member of a small national team, which is arguably unsurpassed in excellence for estate planning. It's given me the ability to serve so many more people. And the clientele of this group includes everybody from a mom and pop all the way up to a former president of the United States. So we are truly blessed at this point in our lives to be able to serve everyone in their estate planning needs. So I think that the flyer mentioned, and I will reiterate it here, that if we end up working together and that we can't demonstrate a strategy to you to save you 5 times the cost of your plan, that's your whole plan, we'll refund your consultation fee, which is priced at $425. So we want to get you fully informed about your opportunities, and we so strongly believe that the tools, devices, methodologies available to us will save you that kind of money, that we're making that money back guarantee for the consultation fee. I didn't see other questions. This would be the time to type them in if you have any. I see that technical one, and I'm going to check over here on the question and answer block. No open questions. I don't see any questions in the chat area. So once again, what if? What if? We never know, do we? So we prepare as best we can. I would encourage each of you to consider moving quickly rather than later to take the maximum advantage of what is available to you now. Some of those options we went over during this half hour. And again, if you work with us and we can't demonstrate a strategy which will save you 5 times the amount of your full plan, we will gladly refund the consultation fee. All right. I'm not seeing any questions, guys. It's been great to be with you this morning. Thank you so much for tuning in. It's going to be an interesting period of time here in America. And I guess by January 20th, we will all know what happened and make future plans. I'm thinking about after the election doing a follow-up, a phase 2. Okay, now we know who got elected and what expectations we might have of those things that we went over this morning. Thank you so much. I'm John Miller, founding attorney with Rock Solid Law, and I look forward to seeing you all again soon. Take care. Bye-bye.